Okay, dreamers, we are going to pick back up right from where we left off, discussing the testing of the tan t-shirt and the suspected planting of Kevin Cooper's blood on said t-shirt. Okay, so we know that Kevin's EDTA preserved blood sample was taken when he was arrested, along with other EDTA preserved blood samples from the victims, which were kept in an evidence refrigerator, to which up to 20 people had ready access to. We also know that blood could be withdrawn from those tubes without breaking any seals. And we know that anyone with access to that refrigerator could take items in and out of it without there being any record of it at all, without any written record. This information, coupled with the EDTA and the DNA findings we've just discussed, strongly suggests that someone in the San Bernardino County Sheriff's Department took blood from one or more purple-topped EDTA tubes and placed that blood on the t-shirt. And the district court did not account for the correlation between human DNA and EDTA in the control samples when it stated, quote, "While the extraction and measurement of EDTA in a sample may theoretically be accomplished, the ubiquity of EDTA in the environment prevents any meaningful interpretation of the significance of an elevated level of EDTA within a forensic sample," unquote. Of that, Judge Fletcher said, "Contrary to the view of the district court, the data to demonstrate that a meaningful interpretation of the significance of an elevated level of EDTA is possible. In fact, they demonstrate that the state's lab test results were probably valid. Neither the state's doctor nor Kevin's doctor were given the opportunity by the district court to look at both the EDTA and the DNA data. When the state's doctor called contamination and withdrew his results, he was not aware of Kevin's lab results. He was also unaware of the results of the DNA testing by the state. We are now able to see what the state's doctor could not see when he withdrew his test results. First of all, the state's doctor was not aware of the remarkable congruence or similarity of his supposedly contaminated results with those of Kevin's lab. Second, the state's doctor was not aware that samples 2, 3, and 4 each contained significant amounts of DNA, which closely correlated with the amount of EDTA in those samples. The state's doctor mistakenly thought those samples contained no blood and therefore should have contained no EDTA. In turn, he thought the samples 2, 3, and 4 were valid controls and that he should have found little to no EDTA in them. Had the state's doctor known that Kevin's doctor got nearly the same results, and if he had known that samples 2, 3, and 4 contained human DNA, which they should not have, rendering them not valid control samples, it is entirely possible, perhaps likely, that he would not have withdrawn his results based on supposed contamination in his lab. It should have been an easy matter to ask the state's doctor, in light of what the district court learned later, whether he would have still withdrawn his lab results, but the district court didn't bother. It is clear from what we have discussed that the district court did not properly carry out our directive to perform EDTA testing on Kevin Cooper's blood on the t-shirt. The court did not permit Kevin's experts to participate in or even see the selection of the t-shirt samples chosen for testing. It refused to allow testing of the newly chosen sample, which was supposed to contain only Kevin's blood, to determine if, in fact, it contained his blood or any blood at all. It refused to permit an inquiry into why vial VV-2, which was supposed to contain only Kevin's blood, contained the DNA of 2 or more people. It refused to permit the discovery of the state's doctor's raw data and bench notes when he withdrew his test results that did in fact strongly suggest that Kevin's blood had been planted. It incorrectly concluded that samples 2, 3, and 4 were proper controls, and therefore incorrectly concluded that the lab's test results could not be correct. And it refused to allow further testing after it allowed the state's doctor to withdraw test results that had been favorable to Kevin Cooper. The test results that we do have strongly suggest that the state's doctor may not have had a contamination in his lab that invalidated his results, and strongly suggest that the state sample, supposedly containing Kevin's blood, did in fact contain an extremely high level of EDTA. In other words, the test results we already have strongly suggest that Kevin Cooper's blood was planted on the t-shirt. And there you have it, dreamers. Evidence planting and proof of it. Next, Judge Fletcher addressed a thing that should never be a thing. False evidence presented at trial. He wrote, "If the EDTA testing already performed shows that Kevin Cooper's blood was planted on the t-shirt, or if further EDTA testing does the same thing, then that showing greatly increases the likelihood that much of the evidence introduced at trial was false. If the state introduced false evidence at trial, it violated Kevin Cooper's constitutional rights to due process. If Kevin Cooper's constitutional right to due process was violated, then he has satisfied the threshold test for showing actual innocence. In assessing whether a federal habeas petitioner has made a showing of actual innocence, the district court is not limited to evidence introduced at trial. Rather, it may consider all relevant evidence. And dreamers, I'd even go so far as to say that they should consider all relevant evidence. Because it is a fact, stuff often comes to light post-trial, and that stuff should count. And then Judge Fletcher went through the false evidence presented at trial. He wrote, "If Kevin's blood was planted, that would greatly increase the likelihood that the following evidence at trial was false. 1. Josh Ryan's testimony. At the time of the murders, he was 8 years old. He was left for dead in his parents' bedroom with his throat cut. He did not take the stand, but his audio and videotape testimony was introduced at trial. The testimony was that he saw either a single man or a single shadow in the house during the murders. This testimony was flatly inconsistent with the information he provided immediately after the murders. One of his recorded interviews that was played for the jury was an audio-taped interview conducted in the office of psychiatrist Dr. Lorna Forbes on December 1st, 1983, 6 months after the murders. The other was a videotaped interview conducted on December 9th, 1984, in the midst of Kevin Cooper's trial. A transcript of the audio-taped interview with Dr. Forbes included the following statements. Question: Who went to bed first? You guys or everybody all together or what? Answer: I think my mom, I, my sister, and Chris went to bed, but my dad stayed up. Question: You don't remember for sure? Answer: That's what I think. Then I heard my mom scream, and I walked in there with Chris and I saw someone. Question: Well, did you mean, where did you see him? Answer: Like over by the bed, my mom's bed. Question: Okay, was the person standing up or what? Answer: And then I went back to bed and... Question: Well, why did you go back? What was happening with the person standing by the bed? Was he standing facing you or what did you see? Answer: He was turning his back against me. Question: Do you remember seeing him doing anything to your mother when she was screaming? Answer: No, I just saw his back and his hair. Question: And his hair? Was he bending over or standing up or straight or what? Answer: He was like his head was down, he was down. And later on in that interview, Dr. Forbes asked Josh, question: You went in there and saw this thing. Do you think it was a man or a woman? Answer: I didn't. Probably a man because women usually don't do that sort of thing. We know in this audio-taped interview, Josh had described seeing a puff of hair on the killer. We also know that the state excised or removed the puff of hair reference from the interview, and that this part of the interview was not played to the jury. During the videotaped second interview conducted in December of 1984, counsel for both sides questioned Josh. His grandmother, Dr. Mary Howell, was also present during the interview. The videotaped interview was played for the jury on December 13, 1984, immediately before the jury heard the audio-taped interview with Dr. Forbes. The prosecutor asked, question, did you ever see anybody in the house that didn't belong there? And when you say it, could have been someone like your mom? Who are you talking about, or what did you see? Answer, I don't really. Saw like a shadow or something. Question, where did you see the shadow? Answer, like the bathroom was here. I saw it right like the bathroom. Question, by the bathroom? Answer, yeah. Question, when did you see the shadow? Answer, when I saw my sister. Question, and how many shadows did you see? Answer, just one. During the closing argument, the last evidence the prosecutor discussed in rebuttal was Josh's recorded interviews. He emphasized the consistency of Josh's story in the two interviews and argued that consistency showed that Kevin Cooper was the perpetrator. We have from Josh the same basic story to different people at different times that have both been tape recorded and videotaped. During the entire time that Josh was with his grandmother, a time of protection and love, Josh told the same basic story. A story that you, ladies and gentlemen, got a chance to hear. The story that shows that there was just one attacker, Kevin Cooper, with a hatchet in one hand and a knife in the other. On the second day of deliberations, the jury requested to rehear the entire audio-taped interview with Dr. Forbes. This was the first of only 2 readbacks requested by the jury. But the story told in the 2 recorded interviews is incompatible with Josh's statements made immediately after the murders. So next we're going to go over what Josh actually indicated right after the murders. Judge Fletcher wrote, when Josh first arrived at the emergency room on the afternoon of June 5th, he was unable to speak because his throat had been cut. Josh's handwriting was illegible. A clinical social worker named Dawn Gamundoy devised an effective way for Josh to communicate basic information. Gamundoy wrote out the letters of the alphabet, numerals 0 through 9, and the words yes and no on a piece of paper on a clipboard. Josh was able to point to the letters, numbers, and the 2 words in responding to Gamundoy's questions. Josh accurately indicated his full name, his date of birth, and his telephone number. Then Josh Gamundoy asked him how many people attacked him. Joshua pointed to 3 and 4 on the paper. Gamundoy asked whether the attackers were male. Josh pointed to yes. Gamundoy asked whether they were black. Josh pointed to no. Gamundoy asked whether the attackers looked like Gamundoy, who is Hawaiian but is frequently mistaken for Hispanic. Josh pointed to no. Gamundoy asked if the attackers were white. Josh pointed to yes. Medical personnel treating Josh in the emergency room described Josh as conscious, alert, and immediately responsive during the time Gamundoy was questioning him. The sergeant in charge of this investigation dispatched Deputy Sharp to the emergency room, and he would be the first member of law enforcement to question Josh. Deputy Sharp entered the emergency room as Gamundoy was ending his own questioning at about 2:23 p.m. on the afternoon of June 5th. Deputy Sharp testified at trial that he questioned Josh in the emergency room from about 2:30 to 2:45 and then resumed questioning again in the CAT scan room at about 3:45. Gamundoy did not accompany Deputy Sharp and Josh into the CAT scan room. Periodically during the interview, Deputy Sharp communicated with the lead investigator, Sergeant Arthur, who was at the scene of the crime at the time. Deputy Sharp's report and trial testimony suggested that even at this early stage of the investigation, the San Bernardino County Sheriff's Department did not want to be tied down to Josh's recollections of events. Deputy Sharp testified that he dictated his report at 6 p.m. on June 5th, but that he never verified that the typed version corresponded with his 2 or 3 pages of handwritten notes. He subsequently destroyed those notes. He testified that he reviewed the typed report 2 days later, after having been out in the field working on the case and after interviewing people about the Lee Slang house. Over the lunch recess during his trial testimony, Deputy Sharp altered the date on the report from June 6th to June 7th to make the date on his report correspond to the date he gave in his trial testimony. That is shady. Deputy Sharp testified at trial that he used a hand squeeze method of communication with Josh, squeezing meaning yes, the absence of a squeeze meaning no. Deputy Sharp testified that Josh wrote his name and pointed to numbers for his home phone number and his date of birth. All other information was done by squeezing his hand in order to answer yes to any questions he asked. At trial, Deputy Sharp could not explain how he had used the hand squeeze method to elicit the first piece of information in his report that he attributed to Josh, which was the victim first advised him that there were 3 white male adult subjects in the residence and he had been asleep. In all likelihood, Gamundoy was the source of this information, not Josh, but according to Deputy Sharp's report, he obtained all of this information himself. At trial, the prosecutor dismissed the information Josh provided to Gamundoy, that the murderers were 3 or 4 white men, as a mistake. The prosecutor contended that Josh was confused and that he had described the killers as 3 Mexican men who had come to the Ryan house during the day of the 4th. Deputy Sharp's report indicated that he received information about the Mexicans in the CAT scan room, where, according to Deputy Sharp, Josh seemed to be more alert. This part of the interview took place after an hour-long break, during which time Deputy Sharp had communicated with the sergeant in charge, still at the crime scene. Deputy Sharp initiated discussion of the 3 Mexicans by asking if there was anyone around Josh's house yesterday that did not belong there, to which Josh responded yes. Then through yes and no questioning and hand squeezes, Deputy Sharp purportedly learned that at approximately dusk there was an older model Chevy Impala, blue in color, 4-door, no primer, that had pulled into the driveway of his residence. The vehicle was a lowrider. Through the hand squeeze method, Josh purportedly provided a detailed description of 3 men in the car, including precise height, build, hair color and length, style and color of clothing, age ranges, and nationalities. After this detailed description, Josh gave the first response that we know is false. Deputy Sharp wrote, "I asked the victim if his family owned a white station wagon. The reply was in the negative. In fact, we know that the family owned a white station wagon." The question that allegedly followed formed the basis for the prosecutor's claim that Josh was merely confused and had no recollection of his assailants. Deputy Sharp wrote, "I then asked him if he felt the Mexicans were the people that were in his house this morning when everything went crazy, to which he advised in the affirmative. When Deputy Sharp again asked the victim if he was sure it was 3 Mexicans rather than 3 white males, the victim advised of 3 Mexicans. The victim then moved his shoulders and appeared to be confused. At that point, the interview was terminated as doctors took Josh into surgery. Deputy Sharp conceded at trial that he did nothing in asking his questions to try to distinguish for Josh between the 3 Mexican males or the 3 to 4 white males he had initially identified as his assailants. Over the course of the interview, Deputy Sharp spoke with the sergeant in charge who was at the crime scene 3 times on the phone. Despite what Deputy Sharp later wrote in his report, officers at the crime scene on that day, including Detective Hector Ocampo, learned that Josh had described his assailants as 3 white men. The communications are confirmed by the police log of the attack, which was entered sometime between 2:06 and 2:29 p.m., describing the suspects as 3 young males driving the Ryan station wagon. Given the times in the police log, Deputy Sharp must have been communicating this information to the sergeant in charge either before he started questioning Josh or within a few minutes of initiating contact. So dreamers, the implication is that Deputy Sharp learned of the 3 males from Gamundoy's interview with Josh, not from his own questioning, as he had suggested. On June 6th, the sergeant in charge, Sergeant Arthur, assigned San Bernardino County Sheriff's Department Detective Ocampo to make contact with Josh. At trial, Detective Ocampo denied talking to Josh about suspects or what happened during the attacks at any point prior to a formal interview with Josh on June 14, 1983. Yet the hospital personnel confirmed that Detective Ocampo did speak with Josh about a Mexican in a red shirt prior to that date. Further, both Josh's grandmother and a nurse on duty June 6th both testified that Detective Ocampo asked Josh substantive questions on that date and that Detective Ocampo took notes about what he was learning. At Kevin's trial, Detective Ocampo initially lied, denying that he took any notes on June 6th. He then admitted that he destroyed his June 6th notes on June 8th after typing up a report. The documentation that Detective Ocampo had submitted to the San Bernardino County Sheriff's Department as of October 1983 gives no indication that he had even spoken with Josh on any date other than June 14th. Yet Detective Ocampo eventually admitted at trial that he had spoken with Josh approximately 20 times during Josh's stay at the hospital, meeting with him almost every single day that Josh was there. The detective also admitted at trial that sometime between June 6th and June 9th, he became convinced in his own mind that Kevin Cooper was responsible for the murders. And it was more than a mere belief that Kevin was responsible. He said he knew Kevin was responsible. San Bernardino County Sheriff's Department Captain Schuler, commander of the Public Affairs Division, made clear at trial that by June 6th or 7th, after Kevin Cooper had become a suspect, the department's publicly stated position was that Josh could not provide any useful information. Captain Schuler testified under cross-examination that he had probably seen the source of an Associated Press report reporting that Josh had told investigators that 3 Mexicans in a blue car had come to the Ryan house during the day before the killings. No public mention was made of the fact that Josh had told Gamundoy before any San Bernardino detectives had arrived at the hospital that the killers had been 3 to 4 white men. On June 14, 1983, Detective Ocampo interviewed Josh about what he remembered about the attacks. Josh was able to speak by then. Breaking with his standard policy of tape recording formal interviews, Detective Ocampo only took notes on what Josh said. He testified at trial that he destroyed his notes after writing his report the following day. At Kevin's trial, Detective Ocampo conceded he could think of no reason to not tape record the interview other than to shape the context that the interview is presented and to shape the information in his report. So, what are we thinking here, dreamers? This detective did not want to have any actual recordings of what Josh was going to tell him. And it kind of sounds like he was going to pick and choose what he was going to include in his final report. Dr. Jerry Hoyle, a psychologist at the hospital, observed the entire interview between Josh and Detective Ocampo on June 14th. Dr. Hoyle took notes to assist with Josh's treatment. His testimony at trial showed that Detective Ocampo's report of the interview had distorted what Josh had said. For example, Josh had used the words they and them to refer to his assailants, while Detective Ocampo's report only referred to one attacker. Reserve Deputy Simo guarded Josh for part of the time while he was in the hospital. Deputy Simo testified that on the evening of June 15th, while he was playing Uno with Josh, the news came on the TV. The program displayed a photo of Kevin Cooper with his hair combed out in a natural afro style. Josh stated without any prompting that Kevin Cooper was not the person who did it. Within 15 minutes, Deputy Simo called Detective Ocampo to report what Josh had said. As a volunteer deputy, Simo was not responsible for preparing reports. Rather, Detective Ocampo had that duty. Detective Ocampo returned Simo's call that evening. Deputy Simo testified that Ocampo told him that he knew about that information, that there were 3 Mexicans that had previously come, apparently looking for a job, and it could have been either because of the trauma, that it was some kind of flashback on that. He also testified that Deputy Ocampo suggested to him that the reason Josh made that statement that it wasn't Kevin Cooper was because of Josh's trauma. And Dreamers, I know that Joshua was traumatized in this incident, but I said it before and I'll say it again. I absolutely 100% believe what Josh had been saying in the hours and days and weeks following the incident, regardless of what he said in those taped interviews. And it is pretty clear that the sheriff's department was actively attempting to shape Josh's memories and his story. And they needed his story to fit their narrative that Kevin Cooper was the perpetrator of this crime. No one from the San Bernardino County Sheriff's Department took an official report from Deputy Simo. Of course they didn't. In May of 1984, Deputy Simo saw newspaper articles about Josh and contacted Detective Ocampo again. Only then did Detective Ocampo ask Simo to come down to the station so that he could make a report. Soon after Josh made this statement to Deputy Simo, he had made a similar statement to his grandmother, Dr. Mary Howell. Kevin Cooper's picture appeared on TV. His grandma asked him whether he had ever seen Kevin before, and Josh responded no. Dr. Lorna Forbes, who we mentioned earlier, was a psychiatrist specializing in treating children who have survived the murder of a family member. She began treating Josh in October of 1983. On December 1st, 1983, 6 months after the attack, Dr. Forbes audiotaped an interview with Josh using questions submitted by Kevin's defense counsel. This was one of the 2 interviews played for the jury during Kevin's trial. And Dr. Forbes herself has questioned whether it was actually Kevin Cooper who committed these murders. Really? Even the psychiatrist treating Josh for his trauma isn't convinced of the story that the San Bernardino County Sheriff's Department is trying to sell here. In a sworn deposition dated October 30th, 1999, some 16 years after she first interacted with Josh, Dr. Forbes stated that she had kept in touch with Josh and Dr. Howell from their first contact to the present day. While professionally and ethically bound to maintain any confidences Josh shared with her during the course of treatment, Dr. Forbes urged the court in 1999 to pursue all opportunities to clear Kevin Cooper. She stated, quote, "I have maintained the opinion that it would have been extremely difficult for one person to have committed the 4 murders and the assault on Josh. It is in my mind that it is imperative that a DNA test is performed to assure as much as possible that an innocent man is not executed." And yeah, that might work if the DNA testing wasn't tampered with. In his tape-recorded interview with Dr. Forbes, Josh said he saw a person with a puff of hair standing over his mother during the attack. He made a similar statement to his grandmother in May of 1984. And it is almost certain that Kevin Cooper did not have a puff of hair at the time of the murders. It is undisputed that Kevin's hair was braided when he escaped from prison on June 2nd. His hair was also braided on June 5th, the day after the murders. A hotel clerk in Tijuana, where Kevin arrived at 4:30 on June 5th, testified that Kevin had braids when he arrived. Another hotel clerk who did not testify provided a sworn statement that Kevin had his hair in braids. However, pictures of Kevin Cooper that appeared on TV after the murders showed him with an afro. That is, they showed him with a puff of hair. The prosecutor excised the puff of hair statement from the audio tape that was played for the jury. The excision of the reference to the puff of hair meant that Kevin's attorneys did not argue to the jury that Josh could not have seen Cooper with a puff of hair during the killings, and that Josh was confusing what he saw on the night of the killings with what he later saw on TV. It also meant that the prosecutor could plausibly represent to the jury that Josh told the same basic story. At the invitation of the district court, Josh Ryan delivered an in-person unsworn statement at the end of the final day of the 2004-2005 hearing on Kevin's second habeas corpus application. Josh testified on April 22, 2005. The first time I met Kevin Cooper, I was 8 years old and he slit my throat. He hit me with a hatchet and put a hole in my skull. He stabbed me twice, which broke my ribs and collapsed one lung. Every time Kevin Cooper opens his mouth, everyone wants to know what I think, what I have to say, how I'm feeling, and the whole nightmare floods all over me again. The barbecue, me begging to let Chris spend the night with me in my bed, Chris on the floor beside me, my mother's screams, Chris gone, dark house, hallway, bushy hair, everything black, mom cut to pieces, saturated in blood, the nauseating smell of blood. Helicopters give me flashbacks of the life flight. My Incredible Hulk pajamas being cut off by paramedics. Bushy hair reminds me of the killer. Silence reminds me of the quiet before the screams. Kevin Cooper is everywhere. There's no escaping him. Dreamers, I'm so sad and so filled with sorrow hearing Josh's words like this, and how this one night completely destroyed his family and his life. But I'm also sorry to say that I feel deep down in my heart and in my soul that Josh is mistaken. It's so difficult to want to say that about this poor young man, but Kevin Cooper has been systematically forced into Josh's recollections of that night. Any doubt that Josh may have had about Kevin's guilt completely evaporated when the DNA testing on the t-shirt and on the cigarette butts found in his family's station wagon came back as a match to Kevin Cooper. To Josh, that evidence is irrefutable, and he's expressed his hopes to be present in the room to watch Kevin Cooper be put to death. The district court denied Kevin's attorney's repeated requests to allow discovery concerning Josh's memory and his testimony at trial. The court also denied Kevin's attorney's request to cross-examine Josh at the habeas corpus hearing. Immediately after Josh made his statement at the hearing, the court required Kevin's attorneys to make their closing arguments. And the district court denied Kevin Cooper's habeas corpus application from the bench the same day Josh testified. The court stated, "I do recognize that the victims who came here today are technically under federal law. It is not mandated that they are required to speak. But I did think, for completion of the record, it is helpful for any reviewing court to hear at least their statements about their views of the matter. And so the court recognizes your objections, but believes that because it is a case of major importance, that it is appropriate to give the victims a say. And it was not a significant period of time, but it does complete the record for the reviewing court." Of this, Judge Fletcher wrote, "Given the district court's refusal to permit discovery and cross-examination, Josh's unsworn testimony at the end of the habeas hearing hardly completes the record. Instead, Josh's testimony at the 2004-2005 hearing raises new questions. In its order denying Kevin's habeas petition, the district court wrote that the videotape and audio tape interviews benefited Kevin because the defense avoided the drama and sympathy that would have undoubtedly occurred had the defense called victim Josh Ryan to the stand in the trial and heard his first-hand recollection about a man with bushy hair. Josh's testimony in 2005 was the first time Josh made an in-court statement that he had seen anyone with bushy hair during the attack. If Kevin's attorneys had been permitted to question Josh in the 2005 hearing, They could have asked him about his recollection of the attacker's bushy hair or puffy hair, and could have pointed out that it was extremely unlikely that the man with bushy hair on the night of June 4th, 1983 was Kevin Cooper, because his hair was braided. Next, the judge addressed the tiny speck of blood entered into evidence as A-41. It again is going to get a little tedious in his report, so I'll try to keep it as simple as possible. But this, like every other detail in this case, big or small, is so important to piecing together the levels of corruption this entire case is fraught with. Okay, so a drop of blood was found by Deputy Bayard on the wall in the hallway across from the master bedroom in the Ryan house. Chips of paint with the blood on them were taken from the wall and labeled A-41. The state introduced this evidence at Kevin's trial through San Bernardino County Sheriff's Department's criminologist, Daniel Gregonis. His testing of A-41 showed that its blood characteristics matched those of Kevin Cooper. During deliberations, the jury requested that Gregonis' testimony about A-41 be read back. This was the second of only 2 readbacks requested by the jury. Remember, the other was Josh's audio-taped interview with Dr. Forbes. There is a strong likelihood that the results of the blood tests performed on A-41 presented at trial were false evidence. There is also a strong likelihood that individuals acting on behalf of the state tampered with A-41 to ensure that it would generate inculpatory results when Kevin's post-conviction DNA testing was conducted in 2002. Gregonis delayed most of his testing of A-41 until he had information about Kevin Cooper's genetic profile. That is, until he knew what he had to match to. He then delayed doing the most sensitive and discriminating testing of A-41 until after Kevin Cooper had been arrested and had the vial of Kevin's blood, vial VV-2, in his lab. Then, without contacting Kevin's attorneys, Gregonis reran tests that consumed more of the limited sample that constituted A-41. Gregonis then tested a known sample of Kevin's blood side by side on the same testing plate with A-41, but he initially denied doing so and represented under oath that he had tested the samples blind. When the results of Gregonis' tests on A-41 were initially inconsistent with Kevin's expert's results for a known sample of Kevin's blood, Gregonis altered his lab notes and claimed that he had misinterpreted his results. This was part of his testimony at Kevin's trial as he is being questioned by Kevin's attorney. Question: did you change your mind about A-41 after you learned your original call was accurate? A-41 could not have come from Mr. Cooper? Answer: not immediately, no, but it was after, yes. Question: prior to your learning that if your original call about A-41 was correct, then it could not have come from Mr. Cooper, how many times did you testify on the witness stand under oath that A-41 was a B and nothing else but a B? Answer: probably 3 times. Question: and your explanation was that it was a technical fault on your part, that you made a mistake? Answer: essentially, yes. So dreamers, the county criminologist changed his findings to again make Kevin Cooper fit into the narrative. Another expert throwing their own career under the bus with claims of mistakes on their part, misinterpretations of their findings, and supposedly laboratory contamination, all for the sake of keeping up the fairy tale that Kevin Cooper committed these murders and the attack on Josh. The lengths that everyone involved in this investigation and prosecuting of this case are willing to go through is truly terrifying. It's hard to believe that nobody in this department or in this district attorney's office, nobody stepped in to say, this isn't right. Everybody was in on this, dreamers. I had once so strongly believed that a conspiracy of this magnitude is virtually impossible because it takes way too many moving parts to make something like this happen. But it actually did happen this time. Everyone, at every level, incredibly, was on board with this. And if you weren't, you were shut out and shut down. Judge Fletcher continued on about A-41. The blood sample in A-41 had a disturbing pattern of being entirely quote-unquote consumed in the testing and then somehow reappearing in a form that could be subjected to further testing. Gregonis had initially used so much of the limited sample, or so he said, that when the parties finally did joint testing, they were forced to place the remaining tiny flakes of white paint in a liquid solvent to dissolve any remaining blood. The sample was so small that their results were largely inconclusive. All of the chips that had had any traces of blood on them were discarded. Then in early July 1984, just out of curiosity's sake, Gregonis opened the A-41 pillbox and saw a very small quantity of blood remaining. The parties tested those remaining specks of blood in October of 1984, and again the results were inconclusive. In August of 1999, Gregonis checked A-41 out of evidence storage for 1 day. When Kevin's post-conviction DNA testing took place 3 years later in 2002, a blood-stained paint chip and blood dust had inexplicably and conveniently appeared in the A-41 canister. The blood on that chip was tested, and Kevin's DNA was found. The appearance of a blood-stained chip in 2002 is, to say the least, surprising, given that Gregonis had testified at trial that in the October 1984 testing of A-41, they had processed and discarded all of the paint chips with blood on them. And then in the 2004-2005 habeas proceeding, Kevin requested EDTA testing of A-41. Without taking evidence on the feasibility of testing any of remaining A-41 for the presence of EDTA, the district court rejected Kevin's request again. Dreamers, the pattern here is clear, right? The district court never, ever granted any of Kevin's motions. And when there was no choice, they were forced to conduct further testing of evidence, everything was tampered with. Things appeared where they had never been before. Things that were consumed suddenly came back. And things were in places where they should not have been. Evidence was destroyed. Witnesses and experts undermined their own work in order to throw evidence out. How much longer can San Bernardino County get away with this? How are they not being held accountable for this garbage? And what the holy hell is so freaking important about keeping an innocent man on death row? And how is it that everyone is willing to stake their entire careers and their reputations for this? I don't have a tangible answer for that, other than this. All of these people are doing everything in their power to not have to look Joshua Ryan in the face and tell him the people who slashed and stabbed your mom, your dad, your sister, and your friend to death, the people who slit your throat, chopped a hole in your skull, and stabbed you multiple times in the back and left you for dead, are still out there. Judge Fletcher circled back to the Pro-Ked shoe prints again. He wrote, 3 matching shoe prints made by a Pro-Ked shoe were critical evidence against Kevin at trial. According to the testimony at trial, 1 bloody footprint was found on a crumpled sheet in the master bedroom of the Ryan house. Another print was found on a spa cover at the Ryan house outside the master bedroom. The 3rd print was found in dust on the floor inside the Lee Slang house near a pool table. First, we need to address the suspicious circumstances under which the shoe prints were purportedly found. The most suspicious of the shoe prints are the 2 found at the Ryan house. The most incriminating was the bloody print purportedly found on the crumpled sheet in the master bedroom. At trial, only one person testified that he saw the bloody print while the sheet was still in the bedroom. That person was San Bernardino County Sheriff's Deputy Duffy. No one else claimed to have seen the bloody print while the sheet was still in the bedroom. However, Deputy Duffy had testified under oath at Kevin's preliminary hearing that he had not seen the print in the master bedroom. If Deputy Duffy was telling the truth at the preliminary hearing, then he lied at trial. Sheriff Deputies Stockwell and Schechter picked up the crumpled sheet from the master bedroom after 5:20 p.m. on June 5th. Neither one of them noticed the blood print, if it was indeed there, when they picked up the sheet. They folded the sheet and packaged it to take it back to the crime lab for processing. Deputy Stockwell testified at trial that sometime later in the crime lab, he refolded the sheet so it matched the way it had been crumpled on the floor of the master bedroom. He testified that this is what brought together the separated parts of a bloody pro-ked shoe print on the sheet, which he was then able to see for the first time. He was unable to specify when it was that he made this discovery, however. Deputy Baird, the manager of the crime lab, where the sheet and other critical physical evidence was kept, testified at trial that he matched the newly discovered shoe print to a pro-ked shoe that he already had in the lab. Remember, it was also Deputy Baird who found the drop of blood A-41 in the hall at the Ryan house. Soon after the trial, Deputy Baird was caught stealing heroin from the San Bernardino County Sheriff's Department evidence locker for his own use and for distribution to others. Well, what do you know? A dirty cop on Kevin Cooper's case. Just exactly what that man needed, right? The other shoe print at the Ryan house was on the spa cover outside the master bedroom. That print was discovered after some delay. Several people testified, even after the print was purportedly discovered, that they had looked at the spa cover and had not seen the print. The head of the investigation, Sergeant Arthur, testified that he pointed out the print to Deputy Duffy at approximately 2:07 p.m. on June 5th, but Deputy Duffy testified he did not know about the print until Detective Ocampo pointed it out to him at sunset that day. Sheriff Deputy Sergeant Gilmore testified that he did not see any footwear impressions on the spa cover on the afternoon of June 5th. Deputy Smith, who was ordered to sketch all of the shoe prints on the spa cover on the morning of June 8th, 3 days later, testified that she had sketched all of the prints that she saw on the spa cover. However, none of her sketches matched the print of a pro-ked shoe. An unidentified officer directed her back to the spa cover later on June 8th. It was then she saw a pro-ked shoe print she had not previously seen. That spa cover was left out in the open, moved several times, and stepped on by at least one deputy before it was taken into evidence. Then the shoe print was destroyed, purportedly in a failed effort to lift and preserve the image. If the shoe prints on the sheet and the spa were planted, then it does not matter much whether a matching pro-ked shoe print near the pool table in the Lee Slang house was also planted. It is possible that Kevin was in fact wearing pro-ked shoes while he was staying in the Lee Slang house, but the shoe print in the Lee Slang house could also have been planted. If the print in the Lee Slang house was not planted, this would mean that the prints in the Ryan house were put on the sheet and the spa cover to match the print that had been found in the Lee Slang house. But the shoe print in the Lee Slang house could have also been planted. The day before the Lee Slang house search began and the pro-ked shoe was discovered, the front door of the house had been left unlocked and other evidence was likely planted in the house. The print in the Lee Slang house was discovered after some delay. Approximately 12 people had walked through the house. Deputy Baird testified that the shoe print had been marked off so that it would not be stepped on by mid-afternoon of June 7th. Deputy Smith, who arrived at 8 p.m. that day to draw sketches of the shoe prints, testified that nobody had instructed her to sketch the print that turned out to be the pro-ked print. Instead, she testified that she discovered that print on her own after first sketching several other prints that she was instructed to sketch, and then walking around the house to look for more suspicious prints. Contrary to Deputy Baird's testimony, Deputy Smith gave no indication that the Pro-Ked print had been marked off at the time she sketched it. So now we're going to circle back to the cigarette evidence. Cigarette and tobacco evidence presented at trial connected Kevin Cooper to the Ryan station wagon. Remember, the station wagon was found in a church parking lot in Long Beach, 45 miles or 72 kilometers west of the Ryan house, 7 days after the crime. Remember that Kevin arrived at a hotel in Tijuana, Mexico, 125 miles or 201 kilometers south of the Ryan house at 4:30 the day after the murders. Kevin had left evidence in the Lee Slang house that he was rolling his own cigarettes and using prison-issued roll-right tobacco. Tobacco consistent with the roll-right was purportedly found on the floor between the passenger seat and the front passenger door of the Ryan station wagon. 2 cigarette butts were also purportedly found in the car. One of them appeared to be made with the roll-right tobacco. The other was a commercial filter cigarette. One of the cigarettes contained evidence that had been smoked by someone with type A blood, which is Kevin Cooper's blood type, and according to Gregonis, is the blood type of about 40% of the population. But testing on the cigarettes before Kevin's trial did not reveal any further information. Judge Fletcher wrote that the San Bernardino County Sheriff's deputies had ample opportunity to plant incriminating cigarette and tobacco evidence in the Ryan station wagon. Most of the cigarette butts that Kevin left behind in the Lee Slang house were never processed into evidence. Their whereabouts is unknown. Kevin's own car had been impounded in Los Angeles after he was imprisoned at California Institute for Men on the burglary charge. A hand-rolled cigarette butt recovered from Kevin's car had been taken into evidence, but it disappeared prior to DNA testing. Roll-right tobacco in a white box was recovered from the closet of the bedroom in the Lee Slang house previously used by Catherine Biblia, but it was never weighed or otherwise measured. San Bernardino County Sheriff Deputy Maschetti obtained a paper bag of assorted smoking tobaccos from the California Institute for Men. When police formally took into custody the station wagon in the church parking lot in Long Beach, the rear door was already unlocked. The cigarette butts and tobacco in the car were not noted in the initial visual inspection of the car, nor were they noted when the interior of the car was first processed for evidence. The cigarette butts first appeared on a handwritten, undated, unsigned list of vehicle contents. So again, what are we seeing here? We're seeing evidence appearing on subsequent searches of the car. I've seen pictures of those cigarette butts in the back seat, and they are in plain view. Yet, they were not seen on the initial search? How convenient. And, not surprisingly, the cigarette and tobacco evidence from the car has a perplexing history, much like that of blood spot A-41. The paper from the hand-rolled butt supposedly found in the car had supposedly entirely been consumed in testing in 1984. At the time of the testing, the paper was 4 millimeters long. The paper reappeared in 2001 just in time for DNA testing. And when it reappeared, it had magically grown to 7 millimeters. Perhaps not coincidentally, the hand-rolled cigarette butt from Kevin's own car had disappeared prior to the DNA testing. So dreamers, the implication here is that there was plenty of cigarette butts Kevin Cooper left laying around in the Lee Slang house and in his own vehicle. Plenty of pieces of evidence to strategically place in order to link Kevin Cooper to the various crime scenes. So circling back to the hatchet sheath and the jacket button. On June 6th, the day after the bodies were discovered, 2 deputies did a sweep through the Lee Slang house, purportedly to check for possible assailants. During the sweep, they were aware that the department had recovered a bloody hatchet from the roadside near the Ryan house, and it was suspected to be the murder weapon. However, they did not report finding any evidence in the Lee Slang house. Other deputies returned the following day to conduct another search. Those deputies discovered a hatchet sheath and a green blood-stained button in the bedroom Kevin Cooper had been hiding in plain view on the floor near the closet. The bedroom was virtually empty, which would have made the sheath and button very easy to see. The bedroom had no furnishings other than a headboard. One of the deputies who conducted the initial sweep of the Lee Slang house denied ever setting foot in the bedroom, where the other deputies later found the hatchet sheath. However, processing of physical evidence in the Lee Slang house showed that that was another lie. Several of that deputy's fingerprints were found on the inside of the closet of the bedroom where the hatchet sheath and the button were found. That deputy's insistence that he never set foot in the bedroom, that he never set foot in the closet, and the presence of the deputy's fingerprints inside the closet of the bedroom, the failure of the deputy to find the sheath and the button in plain sight on the floor near the closet, and their quote-unquote discovery the next day, strongly suggests that the hatchet sheath and the button were planted in the bedroom. Furthermore, the button found on the floor of the bedroom was green. That means it came from a green prison-issued jacket. However, Kevin testified that he was wearing a brown or tan jacket, and this was confirmed by Lieutenant Cornelius Shepard, who worked at the prison. On June 2nd, Lieutenant Shepard was driving near the prison and saw Kevin. He testified that Kevin was wearing what appeared to be a prison jacket and blues. He was jogging towards him, and his hair was in braids. Lieutenant Shepard's handwritten report stated that Kevin was wearing a jacket that was brown in color. In his testimony at trial, he described Kevin's jacket as brown. So, to summarize Judge Fletcher's report, false and planted evidence was apparent in Kevin Cooper's case. If EDTA testing shows that Kevin's blood was planted on the t-shirt, that showing would greatly increase the likelihood that the state introduced false evidence at trial, and the likelihood would then be so strong that the district court would be obliged to find that the state did so. And that false and planted evidence at trial was this: Josh's 2 recorded interviews in which he stated he saw a single man or a single shadow in the house during the murders. The drop of blood labeled A-41 that Gregonis had testified was consistent with Kevin's blood. The bloody Pro-Ked shoe print found on the sheet and on the spa cover, and probably the shoe print found in the Lee Slang house as well. The roll-right cigarettes and tobacco found in the station wagon. The hatchet sheath. The bloody button. Even with this evidence, the state's case against Kevin Cooper was weak. Without this evidence, the state would not have been able to obtain a conviction. If this evidence was false, Kevin Cooper would be able to make a showing of actual innocence. The instances of Brady violations. And just a quick reminder, Brady violations are instances when the state fails to turn over potential exculpatory evidence. Kevin Cooper contends that the state violated Brady in several instances. The failure to provide Warden Midge Carroll's information that Pro-Ked shoes at the prison were not special prison-issued shoes. The failure to provide the disposition report showing that a senior deputy approved the destruction of Lee Furrow's bloody coveralls. The failure to preserve and make the coveralls available. The failure to provide San Bernardino County Sheriff's Department's daily logs showing that an apparently bloody blue t-shirt had been found. And the failure to preserve and make that t-shirt available. In regards to the shoe, the prosecution, in order to tie those shoes to Kevin Cooper, presented evidence at trial that this specific tennis shoe is only manufactured for institutions supplied strictly for prison use within the state of California, unavailable for retail sales, not sold on the street. The general merchandise manager testified that to the best of his knowledge, this shoe is not sold by any retailer anywhere in any state in this country, and the only place those shoes are sent are institutions in California. But just before Kevin was about to be executed, Warden Midge Carroll provided a sworn declaration in support of his motion to file a second habeas application, and she stated in it that she conducted a personal inquiry and concluded that the assertion that the shoe prints found at the scene came from a prison-issued only tennis shoe was inaccurate. And what's more, she told the sheriff's deputy about this information, but they did not pass it on to Kevin Cooper's attorneys. Kevin was granted a second habeas application, and during the course of those hearings, Warden Carroll testified that she became concerned that the sheriff's department investigating the murders had been describing shoe prints at the crime scene as being from a prison-made tennis shoe, a shoe that had come from a prison. She knew that her prison did not have prison-manufactured tennis shoes. She directed her staff to look into it, which they did. There was no special shoe. The shoes at the prison were common, ordinary shoes manufactured and sold in retail stores. She called the sheriff's department and told one of the lead detectives, and she testified she felt a little put off by the detective's response. She made a couple more attempts to contact the sheriff's department about the shoes, but her calls were never returned. Now, the San Bernardino County Sheriff's Department Detective Derek Pacifico testified that he found no record that Warden Carroll had communicated with his department at all. He reviewed all the files and materials related to Kevin's case and found no indication of any contact with her. But he had only been with the department since 1990, and when he was asked if he spoke to anyone from 1983 who worked on the case, he said he did not, and he also said he was not familiar with the department's paperwork for processing phone calls. And another Stride Right executive was called in to provide testimony that basically those shoes were everywhere, directly contradicting the Stride Right representative who was called at Kevin's initial trial. As for James Taylor, the inmate who essentially put those Pro-Ked shoes on Kevin's feet, remember he testified that he issued those shoes to Kevin just prior to his escape. 5 days after the murders, on June 9, 1983, 2 San Bernardino deputies went to the Institute for Men and met with Taylor's supervisor in the gym. That same day, Taylor heard news reports that the sheriff's department was trying to connect the tennis shoes to Kevin Cooper and that Kevin was the primary suspect. After the deputies left the prison, Taylor was told by his supervisor that the deputies had been looking into shoe impressions and that they specifically mentioned a diamond-shaped pattern. Taylor then reported to the recreation supervisor that he had information about Kevin. On June 10th, the prison investigators conducted a tape-recorded interview with Taylor. In that interview, Taylor said that he knew Kevin from the basketball team and that he had given him the Pro-Ked and PF Flyer tennis shoes. The prison investigator wrote a 2-paragraph report of the interview dated June 12, 1983. The report did not mention that the interview had been tape-recorded, nor did it report the mention of the PF Flyer shoes. The tape was not transcribed until early December of 1983 and was not made available to Kevin's attorneys until well after the beginning of the preliminary hearing. James Taylor is the only testimony at trial that definitively placed Pro-Keds on Kevin's feet. His testimony was not consistent with that of the correctional officer who provided Kevin with his tennis shoes. As far as the shoe evidence is concerned, the district court was wrong on 2 counts. First, the court misstated the evidence at trial, that the distribution of the shoes was limited to prison inmates, and that the shoe prints on the sheet and spa cover could have only come from an inmate. The California Supreme Court specifically relied on this information when it affirmed Kevin's death sentence, meaning this false evidence was critical in securing a conviction and a death sentence in this case. Second, James Taylor did not provide credible testimony, and these Brady violations substantially increased the probability that Kevin was not wearing these Pro-Ked tennis shoes during the time he was inside the Lee Slang house. Then there was the issue of the bloody coveralls. Lee Furrow's bloody coveralls were important evidence indicating that Furrow and possibly 2 or 3 others may have been the killers. Diana Roper turned over the coveralls to the San Bernardino County Sheriff's Deputy Eckley on June 9, 1983. At that time, she told him she had reason to believe that Furrow had committed the murders. Deputy Eckley logged the coveralls into evidence at the Yucaipa station of the Sheriff's Department. Less than 6 months later, Deputy Eckley destroyed the coveralls without telling Kevin's attorneys. Deputy Eckley testified at trial that he acted alone in discarding the bloody coveralls, and in doing so, he failed to follow the department's procedures for disposing of property. On December 1st, 1998, more than 15 years after the murders, Kevin's investigator discovered a disposition report for the coveralls dated December 1st, 1983. This report had not previously been disclosed to Kevin. The report stated, quote, "Destroyed, no value, coveralls." The initials KS were also written at the bottom right side of the report. In February of 1999, Kevin's investigator learned that KS was likely to have been Ken Schreckengost, a senior deputy in the property division at the time. The investigator contacted Schreckengost, but he refused to speak to him, telling him, "I don't like Cooper, I won't help him," and he hung up the phone. Schreckengost told a second investigator, "I know everybody who worked the case, I know all about it, but I'm not gonna say nothing. They should have shot that son of a bitch when he escaped." Deputy Eckley also refused to speak with Kevin's investigators. He told one investigator that he could not add anything to the information that was written on the disposition report. And he told another investigator that he would not say anything without his attorney and unless he's dragged into court. He added that he was retired from the department and he owed them allegiance. An investigator for Kevin contacted Schreckengost in February of 2005. This time, perhaps because the investigator was a former police officer, Schreckengost confirmed that those were his initials. He also told the investigator, "If you're trying to help Cooper, you're in the wrong place." He did say that if proper procedures were followed, no property associated with the murder would have been destroyed, and that property with blood on it would have routinely been tested for at least blood type. Since it's become known that Deputy Schreckengost, contrary to Deputy Eckley's trial testimony, that Eckley did not dispose of the coveralls on his own. He had the approval of his superior officer and then he lied about it. The fact that Deputy Schreckengost approved of the disposal of the coveralls was material information that should have been revealed to Kevin Cooper under the Brady rules. It would have impeached Eckley's testimony and identified Schreckengost as the officer responsible for the disposal. Back at trial, the Sheriff's Department lead investigator testified that the reason the coveralls were never processed was quote-unquote neglect. We now know that a responsible officer of the San Bernardino County Sheriff's Department deliberately destroyed material evidence that should have been provided to Kevin. If the prosecution had disclosed who had authorized the destruction of Furrow's bloody coveralls, Kevin's attorneys could have questioned him at the time about the circumstances under which he approved the disposal of the coveralls. But more than 20 years later, during an April 2005 hearing, Schreckengost replied, "I don't know, I don't remember, or I have no idea," more than 50 times. He purported to not remember anything about the policy manual or the rules for handling evidence. When he was asked if he remembered anything about signing off on the disposal, he said, "You know I don't. It's been 23 years. It's worth noting that Schreckengost and Eckley are good friends, even carpooling to the 2005 hearing together. Both of them knew and understood the value of a fading memory in this case. In response to one question during the hearing, Schreckengost answered, "You're talking about stuff that happened many years ago. I can't even remember what I had for lunch yesterday." Yet, dreamers, he somehow remembers how much he doesn't like Kevin Cooper, right? Then, under questioning at the same hearing, Deputy Eckley also answered, "I can't remember what I ate 2 weeks ago." At the 2005 hearing, Deputy Eckley said that he thought the story told by Diana Roper, Lee Furrow's girlfriend at the time and the one who turned over the bloody coveralls, was a very goofy story and that there were lots of holes in her story. When he ran it by his supervisors, they didn't think she had any credibility. But he was told to take the coveralls as evidence and pass them on, which is what he did. But in a May 26, 1984 interview with Kevin's investigator, Eckley said that he believed Diana's story, stating at the time, quote, "She said this guy had come from prison and that he has a rap for crimes like murder. I would believe that part because the Kellison girls, which is Diana and her sister, have a tendency or a propensity to marry, live, and shack up with guys from prison. And with my relationship with the Kellison Roper families, I know their involvement in crime, as far as committing murders, as well as giving up murderers." The investigator asked, "They've done this in the past?" Eckley replied, "Oh yeah, they've given very good information on a murder before. One of their sons tried to commit a murder and tried to kill me once. You know, I know the family. So knowing what Diana said might have validity to it, I called the supervisor. He told me to take the coveralls and place them into evidence." 1 week after his 1984 interview, Eckley was interviewed by San Bernardino County Sheriff's Detective Woods, who was anxious to know what Eckley had said to Kevin Cooper's investigator. This conversation, which Eckley was unaware was being recorded, strongly suggests that it was the Sheriff's Department's plan to pass off Eckley's actions as those of an ignorant deputy who did not know what he was doing. Eckley said in this interview that he was trying to give Kevin's investigator the impression that he was the lowest on the totem pole. "I'm just a field officer who took in the evidence, put the evidence and told my superiors, and whatever homicide and my superiors did, I don't really know. I just heard stuff but didn't know." So based on the discovered disposition report of the disposal of the coveralls and Schreckengost's admission that his initials were on it, we now know that the prosecution committed 2 Brady violations. First, they should have turned over the disposition report to Kevin's attorneys, and second, they should have preserved and made available the coveralls themselves. These 2 failures severely hampered Kevin's attorneys in their efforts to show that he was innocent and that Lee Furrow and his companions are the true killers. So next, there is the blue t-shirt. According to the Sheriff's Department's daily logs on June 6, 1983, a day after the discovery of the murders at 2:41 p.m., a woman named Laurel Epler, who had no connection with the investigation, called the sheriffs to report that she found a blue shirt along Peyton Road and that it possibly had blood on it. The tan shirt that we have discussed at length was also found along Peyton Road, and this suggests that the killers may have decided to shed some of their bloody clothing at roughly the same time. Sheriff's Deputy Field was dispatched and he collected the shirt that day. Now, it has consistently been the state's theory that Kevin acted alone in these killings. If Kevin could have introduced a second bloody t-shirt found along Peyton Road, this would have been virtually conclusive evidence that there had been more than one killer. Kevin's attorneys at trial insisted he was never given, nor did he ever see the blue t-shirt or any documentation referring to it. At the 2004-2005 hearing in district court, the state produced Sheriff's Department's daily logs that contained a 5-line reference to the blue t-shirt. The log for June 6 recorded the following at 2:41 p.m. On Peyton Road and Glenridge, Laura Epler reports finding a blue shirt that is possibly having blood on it. Unit 21D14 handling. Evidence picked up. The state contended at the district court hearing that these daily logs were handed over to Kevin's counsel before the 1983 trial. His attorney maintained that they were never given the logs. However, the district court refused to allow Kevin's counsel to testify at the 2004-2005 hearing to rebut the state's contention that it had given the logs to him. It is almost certain that the state did not give the daily logs to Kevin's counsel before trial. The DA testified at trial that documents turned over to the defense are stamped with a page number relating to the number of discovery when that page was given to the defense. The daily logs introduced into evidence at 2004 and 2005 hearing have no such page numbers. But at that hearing, the assistant DA testified that documents obtained by means of a subpoena do not go through the DA's office, therefore they would not have page numbers. But the state has been unable to produce any record indicating that the logs were turned over to Kevin's counsel pursuant to a subpoena. Other evidence also indicates that no part of the daily logs was disclosed to Kevin before trial. Evidence that a second shirt stained with blood had been found near the place where another blood-stained shirt had been found would have critically undermined the prosecution's theory that there was a single assailant. If they had the evidence, he obviously would have used it at trial. Yet there is no mention of it at any point during the trial of a blue t-shirt, possibly stained with blood, that had been found beside Peyton Road shortly after the murders. And then at the 2004-2005 hearing in the district court, the prosecution argued and the district court concluded that the blue shirt found by Laurel Epler was the same shirt as the tan one found by Deputy Field. There is no entry in the sheriff's daily log mentioning the tan t-shirt. The district court relied on this fact to conclude that the one daily log entry mentioning a shirt must correspond to the tan t-shirt. There is absolutely no basis for this conclusion. The district court disregarded the procedures used by the San Bernardino County Sheriff's Department. The daily log on which Laura Epler's call was recorded is created based on incoming phone calls. The call intake person takes the call, fills out a sheet, and hands that sheet to a dispatcher, who then sends a deputy to respond to the call. After the deputy has responded, the dispatcher records the disposition of the call, and the sheet is used to complete the entry in the daily log. Laurel Epler called in to report the shirt, and there is therefore an entry in the daily log recording it. Epler testified in the 2004-2005 hearing that she recalled that the shirt was blue, and that the location of where she found the shirt on Peyton Road was different from the location where the tan t-shirt was found the following day. Deputy Field made his report the day after Epler's call on the afternoon of June 7, 1983. He had participated in a search for physical evidence in the Peyton Road area. Another deputy brought the tan t-shirt along with an orange towel to his attention. He took them into custody at 5:30 p.m. that day. Because the tan t-shirt was discovered by an officer during the search, there was no phone call to the dispatcher about the shirt. Therefore, there is no way that a reference to the shirt could appear in the daily log. The district court denied Kevin the opportunity to develop the record to learn whether or not the sheriff's department maintained any records of which documents it handed over to the defense prior to trial. What's more, the district court also denied Kevin the opportunity to conduct discovery to learn whether or not other documents relating to the blue shirt, such as evidence tags and radio logs, were not disclosed prior to trial. However, even with the record in its current state, it is now clear based on the daily logs that the state has just revealed that there were two shirts, a blue one and a tan one. The prosecution committed a Brady violation in not turning over the copy of the Sheriff's Department's daily logs that recorded the discovery of the blue shirt. They committed a further Brady violation by not making the blue shirt available to Kevin's attorneys. So to summarize, and let's be clear, the prosecution in the case against Kevin Cooper committed multiple Brady violations. 1, by not providing the prison warden's information about the Pro-Ked tennis shoes not being exclusive to prisons in California only. 2, by not providing a copy of the disposition report on the coveralls with Deputy Schreckengoss's initials on it. 3, by not preserving and making available Lee Furrow's bloody coveralls. 4, by not providing a copy of the daily logs showing Epler's call reporting that she found a blue t-shirt possibly with blood on it. And 5, by not preserving and making that shirt available. Given the weakness of the evidence against Kevin Cooper, if the state had given his attorneys this exculpatory evidence, it is highly unlikely that he would have been convicted. Thus, Based on the state's Brady violations, Kevin Cooper would be able to make a showing of actual innocence. And dreamers, we are not quite finished yet. Judge Fletcher has plenty more to say about why he dissented in the denial of Kevin Cooper's 2009 motion for a rehearing on matters involving his case, specifically the DNA. Now, just so we don't forget, because there are so many things we've gone over in the judge's report that are so important, what the judge is referring to in all of this is that Kevin had filed a petition for a rehearing before the bench. Obviously, his attorneys have many issues to raise about this case, but the purpose of this one was to focus on the DNA testing, but his petition was denied. But Judge Fletcher was one who dissented, and his report outlined the reasons why Kevin should be granted this rehearing. So in the fourth and final part of this series, we're going to finish up with Fletcher's report and finally get to where Kevin's case is at today, because there still is a light at the end of the tunnel for him. And I'm also going to tell you how exactly it is that Lee Furrow fits into this case. So hang tight. We will be back shortly with part 4. I hope you're finding this as fascinating as I do. And until next time, sweet dreams.